distanciel et en présentiel à cette.
So, thank you for taking part in this roundtable. So, we're talking about the legal framework in the cross-border exchange of data. So, it is definitely an important topic when you think we're talking over here. That it's estimated by the European Union that in 95% of investigations, electronic proofs are necessary. So, we'd like to thank our distinguished panel, a very highly specialized panel, to be with us today. So we have the experts on this topic. We'll have Catherine Baubels, who is the head of unit of DG Migration and Interior Affairs of the European Commission, and her unit has established a proposal, the legislative proposals and policies of the European Union to better fight cybercriminality, cybercrime and abuse on children. We'll also have Captain Mathieu Audibert from the French Gendarmerie at the newly created CyberGen unit for the cyberspace and cyber threats, who has prepared a PhD on collecting digital proof in criminal procedures. And at a distance online, we have Tatiana Schopina from the Leiden Dutch University. And Tatiana is Assistant Professor of Cybersecurity.
Donc peut-être, Capitaine Audibert.
Maybe, Captain Audibert, we're going to start with you and go from the field and the requirements of the investigation teams with crime that is more and more connected crime beyond the successful operations with Encrochat, for example. Are we going to start from the existing practice? How do we work on a daily basis with this race against time when we hear that we think that your request is not justified? Well, thank you for this very interesting question, and good morning, everyone. Good afternoon, everyone. Sorry. It is a pleasure for me to be with you today. The way I'm going to develop these elements is from a judicial police when an investigation is started, and I will only talk about this aspect and not other investigations to do with intelligence. As you said quite rightly, actually, in the majority of investigations today in 2021 or 2022, the digital proof, obtaining this digital proof is a fundamental challenge for both investigators and the courts, because the penetration of the digital aspect in our societies, even in emerging countries, makes it that 88% of the population today has an access to the web. 91% of people are using the web daily. 40 million French people have at least one smartphone, and 56% of smartphone users in France use an instant messaging app. Now, the market is evolving so much that the connected objects are on the rise, such as watches, refrigerators, cameras, locks, you name it. All this to say that this penetration of the digital is an added number of victims, an hack surface that is much wider for cyber criminals, and we've seen that with the closing of companies, the massification of work from home and distance learning for all types of students and pupils. Many people were connected to the web, and we've seen, statistically speaking, an increase in cybercrime. Once we as gendarmes or police investigators, because since we've noticed it online, because we are, of course, some intelligence, some monitoring on digital spaces, the most important for investigation is to prove first to whom we can who we can blame for these fact and how we connect these crimes, so allocating the crimes to someone. So the idea is that the person who has committed a crime appears before the court. So we are going to investigate and contact the main companies like telephone operators, manufacturers of smartphones, to collect this digital proof. And the Encrochat affair is one example of groundwork on obtaining digital proof with a specific aspect, because we are talking about organized crime, where we had to resort to a very specific French law, because we had to capture IT information at a distance. Here this is common law, so I am the victim of a cyber harassment on Twitter, for example. We had the Mila case in France that illustrate the complexity to identify the people who had an alias who were threatening this young lady on the web. So we had some investigators requested Twitter to give us information to identify these people. And there was a court case and people were sentenced. So I'm going to be talking to companies. French investigators are competent in France and not in other countries. That's the territoriality for you, and each state has its own investigators. Well, American investigators are not competent in France. Now, the problem is that the major IT manufacturers are not located in France. Then with the European Union, there are other devices, and I will let the other speakers talk about that, but these major companies are allocated abroad, mainly in the States. So we as investigators, we're going to send a requisition to Twitter, to Facebook, to Apple, to Instagram, you name it, and we're going to ask them to communicate us some elements to identify the person who, according to us, has committed this crime, because the idea is to identify this person. What's interesting in terms of cooperation, that in France we have a Supreme Court called the Cour de Cassation that explains that you, investigators, police or gendarmes, can request a company abroad. You are allowed to do that. You're entitled. But since the company is abroad, the company remains free not to answer. It's only normal. From a legal point of view, this is only valid. So you'd be surprised, but the majority of the companies answer, actually. But it has been complicated. It was complicated in the past when we had to investigate, like for terrorism, following the Conflans-Sainte-Honorine and the assassination of Samuel Paty. It was difficult to find some answers from social network, social media, where we had to wait 48 or 72 hours to have an answer to one requisition, knowing that that social media had the choice not to answer. Now, this is what's interesting is international cooperation. If the company doesn't answer, because from a legal point of view, I cannot constrain Google to answer because I'm not competent in the States. If this doesn't work, then we'll have to implement some police cooperation or judicial cooperation devices. For example, in the States, we'll be talking about a treaty of judicial, so-called BLAT, Mutual Legal Assistance Treaty, the MLAT. So we're going to ask our counterparts in police, or the judges in France will talk to the judges in the States, so that the police there or the judge abroad executes what we ask for and give us some feedback. It works, and the issue is that it takes a long time. And time is of the essence in the digital era, especially for certain investigations, because the data is volatile. Another example where the company didn't answer. There was in the press, and it's a very good example, and then I will conclude on that. In the French press, if you've been following what is happening in tech, but this is the fix, so there was a small controversy on a company called ProtonMail. ProtonMail was accused by activists, climate activists, to have supplied data, digital data to France, to French investigators, and criticized, according to the press. I'm only telling you what the public elements are, have blame France for using some so-called anti-terrorist legal devices. Well, this is followed by the Police Nationale, not Gendarmerie. So what I'm telling you is, of course, public because I have no knowledge of this case. So we have some people demonstrating for climate who have occupied the Petit Cambodge in Paris. There was a penal investigation, so people have claimed the fact that they wanted to have a restaurant there and it didn't happen. And so the investigators, the Police Nationale in Paris, noticed that these people, to commit their crimes, organized via a Proton email address. So what did the French investigator do? Very logically try to understand and identify who was behind this email to present the case, and then to the people, so they appear before court for the facts that they are blamed for. So our French investigator, this is all public information. So they sent a request from Proton Mail in Switzerland, in Geneva. And as I said earlier on, as a gendarme, just as a police officer downstairs here, I'm not competent in Switzerland because Switzerland is an independent state and it's not a French département. It used to be, no longer today. Anyway, I'm not competent in Switzerland. I cannot legally constrain a legal company to answer my request. And Proton Mail didn't answer. Now, what's interesting in terms of international cooperation is that in the absence of answer from Proton Mail, the French policemen went to Europol because Switzerland has cooperation agreements with Europol. It so happened that Switzerland, just like France, both states have ratified the Budapest Cybercriminality Convention. Now, if you look into the details of that, Article 14 and 18 provide that the signing parties can implement some digital proof collecting devices for any crime, and the states commit to implementing some internal legal aspects to constrain some service providers to have some identifying data. And this is a very example of cooperation. And it is by chance that I give you this example. Proton Mail refused to answer our French investigator. With the help of the French judges, this request was sent to Europol, and just like there are some representatives from the Swiss state, all this is public. It's on the Swiss Federal Police website. They received this request from France, sent it to the French judge that it was legitimate, and the Swiss justice said to Proton Mail, please communicate this information. So it went from Switzerland, got to Europol, and then it came to France. And that's what was criticized by the activists of this eco association. So from a political point of view, I cannot judge on their action, but there is a legal procedure in course. When you say these are anti-terrorist devices, it's not. It is the common law of collecting digital proof. And this is a very example of international cooperation to exchange data and information that relies on legal cooperation agreements like the Budapest Convention and Europol.
Catherine Bauer-Bulst, la Commission européenne s'engage à faciliter le travail des autorités dans le respect des droits fondamentaux. Peut-être on peut faire un tour d'horizon parce que je sais que votre unité est très occupée par rapport à l'état des négociations en trilogue avec le package législatif sur e-evidence qui tarde à sortir avec le notamment donc règlement, directive et
Oui, tout à fait. Et tout d'abord, merci de m'avoir invité. Je suis ravie de pouvoir participer personnellement. En fait, la dernière fois, j'ai essayé de me rendre sur place et je suis montée dans le train qui me déposait directement à Paris. Donc, j'ai raté le panel la dernière fois. Je suis très contente d'être sur place maintenant. Et merci aussi au capitaine Audibert pour ce tour de terrain très utile qui me permet de m'attaquer aux enjeux légaux directement. Donc en fait, c'est un problème européen et même global. Et c'est une conséquence logique du fonctionnement de l'Internet. On peut presser ces services de n'importe où et dans des cas où tous les éléments du crime sont réunis dans une même juridiction d'origine. Donc il y a la victime, le crime, même le suspect peuvent se trouver tous dans la même juridiction. Et il y a juste cette connexion à l'extérieur par voie du prestataire des services utilisés. Et donc c'est absolument essentiel de partir des moyens d'antan, donc de la coopération judiciaire classique qui a été créée pour une situation tout à fait autre, une situation avant l'avenir de l'Internet, et de trouver des moyens efficaces pour étendre les compétences des policiers et des systèmes judiciaires d'une manière compatible avec les défis d'aujourd'hui. Et c'est pour ces raisons, en fait, on a vu que dans plus que la moitié des investigations, il fallait procéder à des requêtes transfrontalières. Donc, ce n'est pas un phénomène rare, c'est vraiment le quotidien de l'investigateur aujourd'hui. Ce sont des requêtes transfrontalières. Et comme le capitaine a évoqué maintenant, tout ceci repose ou sur le système d'antan de coopération judiciaire, ou bien sur un système volontaire, où c'est aux entreprises de décider de quel pays ils acceptent des requêtes et s'ils répondent ou non. Et ils peuvent refuser catégoriquement. Il y a des entreprises qui ne répondent jamais. Ils peuvent refuser à répondre à certains pays et ils exigent des standards qu'ils imposent eux-mêmes. Donc ce n'est pas un standard judiciaire ou légal, c'est vraiment ce qu'ils décident eux d'accepter. Et donc, face à ces problèmes, la Commission européenne, en avril 2018 déjà, a fait une proposition de loi que j'aimerais bien vous présenter, ou au moins les éléments clés. Il y a 5 points notamment à évoquer, et je commence avec le problème peut-être le plus difficile, comment on peut s'adresser aux prestataires de services qui ne sont pas présents en Europe. Comme le capitaine a déjà évoqué, on a affaire à Google ou à Facebook ou à Apple, et Apple nous a raconté qu'ils ont déjà reçu des requêtes dans leurs boutiques dans des villes européennes. Donc il y a des enquêteurs qui sont venus, qui ont dit « il me faut des informations d'Apple, vous êtes présent avec votre boutique, donc il faut que vous me répondiez ». Donc aussi pour les entreprises, c'est très pénible. Et du point de vue de ces entreprises, ils ne sont pas présents en Europe en ce qui concerne l'accès aux données de leurs utilisateurs. Donc il faut chaque fois aller vers les États-Unis pour obtenir des informations. Donc comment est-ce qu'on peut procéder pour créer un système parallèle, parce qu'ils sont présents sur le marché, mais ils ne sont pas présents de manière juridique sur le territoire européen. Donc, on a décidé de les obliger de nommer un représentant légal en Europe, dans un pays membre de leur choix, qui peut se voir adresser avec les instruments qu'on a créés. Et ça, c'est le deuxième point. Donc, on a créé, ou on a proposé de créer 2 injonctions européennes. La première sert à la production des informations. Donc, l'identité d'un utilisateur, les données de trafic, le temps d'une connexion ou même les contenus d'un message, d'un mail, d'un texte. Donc on a créé une injonction avec des conditions assez strictes. Donc il faut que chaque injonction soit vérifiée par une autorité judiciaire. Et pour les injonctions pour des données plus sensibles comme les métadatas ou bien les contenus, ils ne sont pas permis, ils ne sont pas autorisés que pour des crimes plus sévères, comme l'abus sexuel des enfants ou bien des crimes qui se voient pénalisés avec une sanction d'au moins 3 ans de sanction. Et tout cela, on a allié à des délais assez courts. Donc maintenant, il faut que les entreprises répondent dans un délai de 10 jours. Si jamais ils ne répondent pas, donc s'il se voit face à un ordre provenant de la France et le représentant légal est établi en Allemagne, en fait ce n'est pas pour la France de les contraindre à répondre. En ce moment, la procédure passe en Allemagne et en fait c'est pour les autorités allemandes d'obliger l'entreprise à répondre via leur représentant légal. Donc on respecte quand même le principe de territorialité, mais on autorise les autorités françaises, dans cet exemple, de demander directement une production de preuves du représentant légal. La deuxième injonction concerne la préservation des données. Donc, au lieu de directement demander la production, l'autorité peut aussi demander une préservation pour une période temporaire des données pour pouvoir procéder à un ordre de production plus tard. Et ceci est notamment nécessaire quand on se voit dans une situation de conflit de loi. Donc, il n'y a pas que des entreprises européennes qui soient impliquées. Il y a parfois des lois dans les États tiers qui défendent aux entreprises de répondre à une telle injonction. Donc, on veut au moins les obliger de garder les données et permettre aux enquêteurs de lancer la demande officielle, par exemple par voie de coopération judiciaire classique, pour obtenir les données. Et on ne veut pas contraindre l'entreprise de violer ces lois d'établissement dans le pays d'origine. Donc ça, c'est l'injonction de préservation. Et tout ça, on a associé avec des garanties très solides et des voies de recours spécifiques. Donc les deux types d'injonctions ne peuvent pas être mis que dans le cadre de procédures pénales. Et toutes les garanties des procédures pénales européennes sont acceptables et sont applicables. Et là, on a déjà fait beaucoup d'harmonisation, donc on a un niveau assez élevé de garantie et pour le suspect, voire accusé, et pour tout autre témoin qui se voit impliqué. Donc les nouvelles règles garantissent une protection solide des droits fondamentaux. J'ai déjà souligné l'intervention des autorités judiciaires, donc chaque requête. Donc il faut vraiment qu'il y a quatre yeux ou deux paires de yeux qui vérifient tout ordre. Et on a limité l'accès notamment aux données de contenu ou aux données de trafic aux crimes plus sérieux. Et en plus, on a introduit des nouvelles voies de recours. Donc, toute personne qui se voit face à un tel ordre peut porter plainte dans leur juridiction pour contester la recevabilité de l'ordre. Et nous sommes convaincus que le nouveau système qu'on essaie de mettre en place va procurer une sécurité juridique aussi pour les entreprises, qui d'ailleurs nous ont demandé de procéder à une proposition européenne parce qu'ils se voient un peu dans l'embarras avec un système volontaire pour certes et un système de refus catégorique pour les autres qui aimeraient bien jouer leur rôle en ce qui concerne la protection des victimes de crimes et qui veulent des règles stables et solides pour pouvoir répondre aux injonctions. Donc, où en sommes-nous aujourd'hui? Comme Sarah Jane a déjà évoqué, le processus d'adoption est en cours. Les deux institutions européennes qui participent à la législation, c'est le Conseil de l'Union européenne et le Parlement européen, ont établi leur position chacun de leur côté. Et maintenant, on se trouve dans la phase trilogue, qui veut dire que les trois institutions se réunissent en négociation pour trouver un compromis entre les positions du Conseil et du Parlement. Et il faut dire que la position du Conseil est assez proche de la proposition de la Commission, mais le Parlement européen veut revenir un peu vers le système classique de coopération judiciaire, notamment en impliquant systématiquement l'État membre où le représentant légal de l'entreprise est établi. Donc les positions sont assez distantes l'une de l'autre. Donc ça va durer encore. On aimerait bien clôturer ce dossier au plus tard sous la présidence française le semestre prochain, donc entre janvier et juin 2022. Et enfin donner aux autorités judiciaires et autorités de police des moyens aptes aux défis d'aujourd'hui à l'Internet.
Merci beaucoup Catherine Bauer-Bolz pour ces éléments très précis et très importants et aussi par rapport au calendrier en lien avec la PFUE. Professor Chopin, I believe there are specific concerns on the e-evidence proposal. Perhaps you could elaborate upon them?
Thank you very, very much. And I must admit that because I don't have English translation, I just discovered that my French is much better than I thought. Oh. So I understood like 85% of what was told here, but I'm sorry if I misunderstood it a bit. So about the e-evidence proposal, I would like to start a bit with a fundamental question. Why do we need these traditional mechanisms? Because Catherine, as far as I understood, outlined the big position of the European Parliament and LIBE Committee of the European Parliament, that they rather insist on, you know, sort of integrating these classic mechanisms of the mutual legal assistance into the new proposal. So to me, as much as I understand that these classic mechanisms of mutual legal assistance, or in the EU we already moved to actually mutual recognition of decisions, right? So it is much faster. But they do not exist on a whim. So this is the question of protection of fundamental rights, and I'm not saying anything new here. I do understand that these mechanisms are utterly and absolutely unfit to protect the victims of crimes, to protect society, you know, as a whole. But on the other hand, they do serve the function of protecting society from abuse, from abuse of privacy, from intrusive investigations in the countries that do not adhere that much to the rule of law. And if we are talking, and as far as I understood, they were mentioned absolutely domestic cases, like, for example, the victim is in France, the crime was happening in France, the suspect is in France, and only data is abroad. Let me go a bit outside of Europe and turn it the other way around, like when a totalitarian or authoritarian regime is trying to prosecute a political activist under its domestic provision. The victim is there, the country, right? The criminal is there, supposedly criminal, and the data, let's say, is in Europe. Europe has the right to refuse this request because it is a political offense. Now, let me bring it back to the EU. In the EU, not every country is adhering to the rule of law, and I'm going to say it loud and clear. As a German citizen, I do trust my country. Perhaps French citizens trust their country, but some of the countries I will not trust. I will not trust that they are not going to prosecute a journalist or a political opponent or somebody else. So first of all, by removing these layer of double protection which exists in the classical mutual legal assistance mechanisms, we are opening the door for abuse even within Europe. And secondly, what bothers me even more than that is the role of internet providers or service providers in all these, you know, redesign system of, you know, moving from old classic mutual legal assistance to the new mechanisms. I do not believe that they are equipped either from the legal point of view or from the point of view of the division of regimes of accountability between the state and the private industry in terms of who takes the decision to give this data. First of all, they're really not in a position to assess the legality of the request. We have how many states? 20 plus. Secondly, they're not in a position to really refuse it. And of course, it is hard for me to know where trilogue is now. Catherine, you probably know that it is quite closed, and I'm trying to find information where you are exactly there and what has changed. But everything I can see is what was before you went to this trilogue. So this is the documents I'm speaking about. And if I'm wrong here and something changed, please do let me know. So yes, and this role of the private industry, which is now empowered but not accountable in the same way that the state is accountable to their citizens. This is what concerns me a lot. And I know that 20 plus civil society organizations wrote a letter about this. I know that European Data Protection Board was concerned about all this. I know that Libe Committee of the European Parliament is concerned. And I have been working in this area from, policy and law point of view and with police and law enforcement agencies for a long time. And believe me, I want police to have quick mechanisms to access the data. And I think that the idea of having this quick freeze, of having this, order which will preserve the data is a brilliant idea. The mechanism where providers are going to give the data without any involvement of the state where the data is requested is not a good idea, because these entities, these private providers, are not accountable in the same way as state accountable to their citizens, and they're not in a position to be accountable. In the best way, they're accountable to their shareholders, but not even to the users, and not even accountable, they're just liable. And for those of them who really want to help, basically this proposal puts them between the devil and the deep blue sea, because they can face liability in front of the users and also in front of the states. So I'm just afraid that we will end up with rubber stamping of a lot of decisions. And I do understand that many of them will be valid legal requests, and only a tiny fraction of this might be abusive, might be frivolous, might violate fundamental rights. But I also do believe that fundamental rights protection mechanisms exist exactly to protect those cases, to protect those tiny fraction of people, of users, from abuse. Because at the end, it's like we might pull one or two hairs out of our head and think that, oh, that's okay, we still have a lot. But this is how, the watering down of the rule of law starts. So one day we can just wake up and find out that we have no hair on our head. So thank you.
Thank you, Professor Tropina. Face à des conflits de normes.
So, Captain Audibert, so faced with the conflicts of law and jurisprudence, the completing of work on European law is urgent if we want to have a freer flow, seamlessness of investigations. Well, to talk about the obtention of the proof, what's indispensable is that you have some harmonization of the devices of cooperation or judicial devices. Two examples. When a gendarme investigating requests Twitter to have information, so for example the email address or the phone number or the IP address connected to a Twitter alias, to identify that the person who has committed the crime, apology of terrorism, pedopornography, selling QR codes for this health pass. These are things that are happening on a daily basis. When they request Twitter, they're not going to ask Twitter France. Twitter France only makes marketing and representing the Twitter brand. He'll be talking to Twitter International in Ireland. When a gendarme who is investigating is going to make a requisition to try and identify the owner or at least the user of a Snapchat account, for example, that offers QR codes for anti-COVID health pass or the delivery of drugs to Paris or Lyon, things that we see on a daily basis on social media. And they talk to Snapchat in San Francisco, because Snapchat France, people working here in France, are only here for marketing and communication about the Snapchat brand. So it is an urgent requirement for investigators and magistrates, and also for the victims of violations, because we're not going to the details because I'm not allowed to, but I could mention cases where French victims complained to France, to gendarmerie or police stations for actual facts that we could testify. What happened on internet, on the social media or on a website actually was a violation to our own laws, French laws, when we talk to major companies located outside the French territory, outside Europe, when these companies didn't answer, what happened in the end? The prosecutor had to classify this, and the procedure stopped, and the victim was never aware of that prejudice. We're not talking here about, as we can hear sometime, have society controlling the web. Even in our French laws, there are monitoring systems that are really developed. We cannot do anything just because the validity of the procedure depends on that, because we could have the Supreme Court break that, but also the European Court of Human Rights or the European Court of Justice on the also the connection data, which is a major topic as well. We are working for the victims of violations, because someone tells the justice a situation that should have an answer, because you cannot tolerate in 2021, as I saw last night by just watching social media, that people have pedopornography contents on social media that is so well known. So I think this is intolerable. So we must identify these people, and if they're abroad, ensure that the states with whom France and European Union have had cooperation, these people can appear before the court, because there are some victims behind that. Thank you, Captain, for making this clearer and not lose sight of victims of violations that are waiting to some remedy. So, Catherine Parvos, the Council gave the Commission to negotiate on behalf of the European Union with the United States concerning access to digital proof, as well as taking part in negotiations of the Council of Europe on a second additional protocol to the so-called Budapest Convention. Where do we stand? Well, actually, yes, we received the mandate 2019 for both negotiations. I will start with the Budapest one because it is the most advanced. And actually, even if we manage to establish some internal rules, we must also have a solid foundation for more global cooperation. For us, the Budapest Convention, as Captain mentioned, provides this legal basis. It is actually open to non-Council of Europe members, so we have 66 parties to the Budapest Convention, dating back to 2001, and the second additional protocol used to update the convention to better face together the challenges of the digital era. The negotiations have not been easy, but last May we managed to have a text approved from a technical point of view between the 66 parties to the Budapest Convention, so that it is a major success. And today the text of laws have been submitted to other decision-making procedures of the Council of Europe, so the Council of Ministers, which should make a decision by November. And this has been planned at the day of the 20th anniversary of the Budapest Convention, on 17th November. There will be a ministers' meeting who hopefully will approve this text. So what do we have in this new protocol? You will not be surprised that, again, the digital proofs are the most significant part of this, because all parties agreed that we had to proceed with requests that were quicker and more efficient. Therefore, the text that is available online, so I invite you all to go and look it up, provides for direct cooperation with service providers and including entities providing services for recording domain names. In the other parts of this is very technical phrase of registries and registrars actually talk about the people who give the right of using a domain name on the web. As you may have seen, the information on a user or search name was public up to a few years back, and they're no longer public because this was not compatible with the European right of the protection of data. Well, this is still a very important track in a cyber investigation. Who is behind a domain name? And this is why the new protocol now includes a provision that allows for a direct request to the registrars and registrars to know who is behind a given website. The protocol also provides for accelerated cooperation between parties for the divulgation of information about subscribers, identity, and data related to traffic contrary to the European rules. There is a possibility to involve the member state, the party to the convention, receiving the request. So we will not directly go to the operator for European countries. We will go through the authorities, but through a quicker channel. Why is that? Because we don't trust as much as 66 parties of the convention that within the European Union, where we have harmonized the right of protection of data and implemented, as I mentioned before, some procedure, legal procedure protection. So cooperation will not be as close, but much more efficient than what we had known before. And we are also implemented a new system for cooperation, accelerated divulgation in emergency situation. If really there is a question of helping or giving first aid to a victim, we have much more accelerated procedures. And finally, we have reinforced the protection of data and other guarantees of the law and implemented some extra guarantees. So we, as European Union and Commission, are very happy of having seen this negotiation completed successfully. And it is even more important for international development within the UN, which we'll talk about later. But I just wanted to conclude by informing you that for the other negotiations with the states, with the United States, we have for the moment put this negotiation on the back burner because we have to expect that our internal provisions are completed. The idea of the negotiation with the states is to eliminate the conflicts of laws between both jurisdictions. And if we are determined on our side what is the law that applies, because we are still establishing that, it's pointless of trying to eliminate these conflicts. So we are going to restart our efforts as negotiations progress internally to be in a position to establish a system that is robust, efficient with the United States, especially concerning the exchanges of proof, concerning the contents of messages. Thank you very much for all these elements and this timeline, this calendar.
Perhaps, yeah, we could draw a comparison. I think those concerns you were mentioning earlier about the e-evidence are somewhat solved in the second additional protocol to the Council of Europe's Budapest Cybercrime Convention. From your standpoint, can you elaborate? Yes. Oh, we cannot hear you. I think the mic is off.
Sorry, we cannot hear you. Working now, Tatiana.
You can hear me now. Okay, good. Thank you. I'm sorry about that. So I think that Catherine already answered this question to a great extent, and I just want to say that I fully agree with her. First of all, I want to say that I'm a big supporter of the second protocol to Budapest Convention, because I think that During the negotiation, it really changed a lot, because I think that at the beginning it was rather inclined, you know, to go to this uncharted field of direct requests. But they did listen a lot to civil society and to other concerned parties. But also, as Karen said, you do not want to trust every country which is the party of the Budapest Convention, which is perfectly normal. So I think that the Budapest Convention took this huge step, which actually also requires a leap of faith of these various countries to provide us a huge opportunity to improve these mutual legal assistance mechanisms that we have now, with more streamlined mechanisms for cooperation, for submission of requests, shorter timelines, mechanisms for cooperation in emergency circumstances, which are very important, as Mr. Audibert said as well, in all these situations, to be able to get the data quicker. I do recognize that, contrary to what I said, that I'm not a big supporter of direct requests without involvement of the authorities in the requested state. I do appreciate the article they have about domain names, because domain name registration data, because to me it is very balanced. It does not oblige the entities to give the response, right? It empowers them to give it, and the state can actually opt out or provide additional measures if they are concerned. And again, I do think that this is a very balanced approach. If I think about European evidence proposal, as I said, I have no idea how the trilogue is going to end and where we are heading here. I do think that perhaps the European negotiations can take a closer look at this protocol that is adopted, and think that maybe these streamlined mechanisms can be more aligned with what is proposed in Europe, and perhaps better improved with, you know, shorter timelines, and perhaps like more, not perhaps, actually more robust safeguards. And I think that this second additional protocol can serve as a great example on, you know, building more closer cooperation within the region. But to the issue of trust, like, we do not want to trust countries outside of the EU, which is very much, you know, speaks to my heart. I do understand that some of these countries are not exactly countries that adhere to the rule of law strictly. But also sometimes when we see what is going on within some of the EU countries, the question of trust, in my opinion, can still be there. And how does Europe protect itself from abuses in this sense? Thank you.
Thank you very much, Professor Chopina. Avant de prendre quelques questions, on va faire...
Before taking some more questions, we are going to do one more roundtable. Captain Audibert, we're talking about serious crimes. Isn't it at the legal level that we can counterattack those problems? So in fact, to conclude on what I was saying earlier on, the cross-border information exchange makes international cooperation paramount. And thus, as investigators, as magistrates, we also need a legal framework. And e-evidence is, people cannot wait for having this protocol implemented. Because as lawyers, as magistrates, it really simplifies the whole procedures. Because for now, as we have no legal European framework, as e-evidence is a law and a legal framework. But as we have no common law at the moment, each state has its own legislation. And so for this reason, we have to have partnerships, we have to cooperate with the different countries, even countries that are not part of Europe. So that makes it more complicated for us. And if we're trying to get another perspective on that, I think the biggest challenge that we have when it comes to all of these different regulations that we're trying to harmonize through the European law, the idea here is to find the right balance. We're not here to request things always on demand. We need to find the perfect balance so that the right to privacy is being respected, but so that we can also get the information that we need to prosecute the people that needs to be prosecuted. I think that the digital era raises a lot of questions, And I don't think we'll have enough time to get into details, but if you take the jurisprudence when it comes to the data, so from digital rights to the most recent case that we had, it raises a lot of questions when it comes to the dangers or risks that we might be facing in investigation. So the idea would be, are we violating the right to privacy at this moment? You were talking earlier on about serious criminality. When we're talking about serious criminality, which is a word used in the European Commission, but also on the web, raises a question: what is a serious crime? I mean, in France, a crime is always serious. Is an offense serious as well? I mean, if you insult people because of their sexuality, is it serious? What about child abuse? Is that serious as well? And the cyberbullying, for example, this is an offense as well, but is that a serious crime? So this raises question. I mean, I have my own point of view that I'm dealing with in my own thesis, but this is topics that raise questions. It's a very complex issue, and international cooperation is essential, especially when we are under a harmonized legal framework, so that magistrates can always be in the middle and control what's happening, and so preserve this right balance in between the right to privacy, but also the search and identification of suspects and criminals. Thank you, Captain Audibert. I think that we need to find you on Twitter, come Cybergen. And what is your Twitter account? John Audibert, then. And so you are on Twitter and you share the news. Yes, I'm trying to talk about news, but while being careful. So, Catherine, you were talking about compliance, and I was wondering how the European Commission was able to deal with the new initiatives, such as the ones that we have with the United States, Russia, and China. Yes, thank you. I'd like to make some remarks, because we have to say that with the voluntary system that we have now, there are no guarantees. So companies have to decide whether they want to accept or not. So what we're trying to create at the moment, and this is our opinion as well, that it gives much more guarantees compared to what we have today. And to go back to the concept of serious criminality and what is used at the level of the European Court of Justice that identified pedopornography as a serious crime, this also raises question at the European level. How can we define crimes that should have a European response, especially when it comes to injunctions or the preservation of data? And when it comes to the quick freeze, which was supposed to be a magical response, we have to know that if I get an IP address, or if I get this IP address stored, I can't use it if I get that IP address 5 days afterwards, because the IP addresses are dynamic. So one person can connect under one IP address, but will not be associated to this same IP address a few days later. So here, the preservation mechanism that we have now is useless, because it doesn't work with this type of dynamic IP addresses. So when we're asking for data outside of our own jurisdiction, usually people give up. And as the captain was saying earlier on, those cases are then classified. So of course we're asking for more guarantees, and I think that I should try not to throw out the water with the baby with the bathwater, because I think that a lot of people are scared that we might start to go too far and to abuse the system, and so we need to make sure that we're protecting the system as well and that we're protecting people. So we should try and implement mechanisms at the European level. And I also wanted to add a few words regarding those initiatives when it comes to the United Nations. So the European Union, at the moment, we are supporting the Budapest Convention. It's open to everyone. Everybody has access to it. So for now, we don't see why we would need a new convention. And we are really happy with the guarantees that are included within the Budapest Convention for now. And we're not firmly convinced that we'll be able to get the same guarantees, especially when it comes to an internet that is accessible to everyone, where everyone can express their own opinion. So for now, we would rather have the same parties at the Budapest Convention, and we've been able to have a lot of investments as well to get some more capacities, especially for third-party countries that want to get included in the Budapest Convention. And for us, this is the simplest way to do things so that we can have very reliable global mechanisms to fight against cybercriminality. But of course, we remain open to additional regulation that do not go against what we already have. And we will be participating in negotiations, keeping that in mind. Thank you.
An internet governance specialist, what do you make of this other initiatives and the intention of certain countries on the global stage to create new sets of cyber norms?
Thank you very much, Sarah, for your question. And briefly, I fully agree with Catherine here. Budapest Convention exists and it provides high standards, and honestly, my understanding that there is a political message behind this, that the countries who want to control internet, who want internet to be less open under the auspices of security, under the narrative of security and safety from crime, can use and abuse this process to lessen, to lower the safeguard that exists in the Budapest Convention. And in my opinion, the European Union has a good chance here, on the one hand, to participate in negotiation, to take a strong stand, and to ensure that the new binding agreement, because it is going to be a binding agreement if it's adopted indeed. And right now, the proposals for from those countries, they are pretty much, propose overreaching criminalization, and there is a need to take part in these negotiations and ensure that human rights, fundamental rights, and safeguard standards are adhered to. But if not, I do believe that European Union and democratic countries can safely walk away from this process, not vote for this convention, and then it wouldn't be applicable. And of course, it will end sadly with, duplicated standards. One of them would be on the UN level and would be much lower, but at least it would protect the citizens of democratic countries from, abuse. On the other hand, of course, it will bring us back to the territoriality principle and fragmentation of legal frameworks instead of harmonization.
Thank you, Professor Ciopina. Une ou deux questions avant qu'on conclue.
Thank you so much for your remark. Is there any question in the room before we close this session?
Et une question pour Madame de la Commission européenne.
I have a question for the lady of the European Commission. To which service providers will this regulation apply? It applies to online service providers, platforms, social media, but also registries and registrars. So infrastructures, internet infrastructures, and telecom, classic telecom companies. Are the exchange of cryptocurrencies included? No, for the financial systems, we have dedicated systems. We have excluded all the financial systems. Are there some constraints for those companies who would not provide? Are there any measures, well, yes, there is a legal constraints. So you have to have an appointment of a legal representatives, and for the non-appointment of a legal representative and not answering requests. But we use the system of the country where the company is located. Well, just in case I'm talking about when you have your data in different countries and therefore do not answer a legal request from justice. Have you thought about that? Is there something that is provided in this regulation? Well, yes, we have planned some financial penalties, and if there's no establishment in the European Union, it is not very clear because there are some offices in Berlin, so we have to see how European justice can actually constrain such a company to answer. But I must say that most companies expect a clear regulation and have already mentioned that they're going to appoint very quickly their legal representative, and that they are very happy to see some clear regulations on injunctions. Thank you very much. Thank you very much. Do we have any further questions? Well, in that case, oh, we do? Yes? Okay, actually we do, yes. First row. You've been explaining that for mobile telephone manufacturers also based abroad to obtain the data, sometimes the data are encrypted on terminals. Is that something that is a constraint when you're talking about a criminal investigation? Well, the encryption of terminals or devices could also actually be the subject of a different roundtable, because technically and legally it's very interesting with a major case between Apple and the FBI in the States. In France, there is an infraction, violation of the French law that sanctions the owner of a device if he or she refuses to deliver, including investigators, is the secret convention of a mean of encryption. And the Supreme Court in France has judged that for those telephones, smartphones are encrypted like iPhones, the fact that you don't give your code to unlock this phone is a violation. Now, if it is ripe from a legal point of view, because we have the opinion of the Supreme Court, I know, because lawyers have communicated, several requests have been put to the Human Rights Court, European Court, because it has to do with the right of not answering and so on. And to give you a quick answer and conclude, if that person refuses to cooperate and answer the legal request, we have some legal instruments that exist in French law and technical capacities in gendarmerie to just decipher or go around the encryption. In that case, we will need to devote a lot of time to explaining how we do this. So it is not requested from the manufacturers to give the key. No, it was never been the case at gendarmerie, and I believe that I don't make a mistake, it's never been of the interest of the states to weaken the security of the devices or create some backdoors, but personally speaking, it seems dangerous to encourage, to facilitate the installation of backdoors on devices, because you never know if these backdoors cannot be used by criminals and hackers. Thank you very much to our three speakers for the quality of their presentations, and we wish you all an excellent FIC forum. Thank you very much. Have a nice day.